Good afternoon and welcome to NYU School of Law. We are delighted to host the Sidney Shainwald Public Interest Lecture here at NYU. I want to begin by extending profound thanks to Sybil Shainwald and her family for their generosity in bringing this extraordinary series to our campus. And I would also like to thank our alumnus, Ken Feinberg, whose close connection to Sybil has made this collaboration possible. The Shainwald Lecture Series was established 20 years ago by Sybil Shainwald in honor of her husband, Sidney, a tribute to his remarkable career in public interest law and his commitment to accountability. Over those years, the lecture series has included many esteemed speakers, including two other women who served on the Supreme Court of the United States, Justice Sandra Day O'Connor and Justice Ruth Bader Ginsburg. And we are especially delighted that the Birnbaum Women's Leadership Center has now joined forces to host here the Shainwald Lecture this year. I would love for everyone to take a moment to hear a little bit about the Birnbaum Women's Leadership Center. This is an initiative that is something the law school launched with the support of Sheila Birnbaum and Sarah Moss, two of our trustees, and also a group of dedicated advisory board members, many of them our distinguished alumni who are here today. In a short period, the Birnbaum Women's Leadership Center has established itself as a leading force on a number of topics, including gender equity, both within the law school and in the broader legal community. Last year, we were proud to formally elevate what was the Birnbaum Women's Leadership Network to a center to emphasize its place within the law school, that it has surely earned its reputation as a prominent catalyst for discussion and action on a number of topics. And we look forward to seeing the center continue to grow and thrive. Before introducing today's speakers, just a couple housekeeping rules. First, we have a professional photographer who is here today, and photos will be we will have time to pose after for photos. So please note there are no individual photos. Please do not record this session in order to interfere with the program. The event is also being live streamed across the hall in Tishman Auditorium to a group of very energetic students. And it will be shared via the NYU Law channels later this fall. It is my delight to introduce this fireside chat with the Justice and Professor Murray. Melissa Murray is the Frederick and Grace Stokes Professor of Law here at NYU. She is faculty director of the Birnbaum Women's Leadership Center. In 2023, she was honored with the American Bar Association's Margaret Brent Award, recognizing her contributions in advancing the status of women in the profession. Her scholarship focuses on the Supreme Court and the legal regulation of sex and sexuality. In addition to her academic work, she is also a New York Times #1 best-selling author. Together with her co-author, our very own Andrew Weissman. She holds degrees from the University of Virginia and Yale Law School, and she began her career by clerking here on the Second Circuit for Justice Sonia Sotomayor. And Justice Elena Kagan. Justice Kagan, Associate Justice of the Supreme Court of the United States, is a New Yorker. She holds a bachelor's degree from Princeton, an MPhil from Oxford, and a JD from Harvard. She clerked for Judge Abner Mikva on the D.C. Circuit, and then for Justice Thurgood Marshall at the Supreme Court of the United States. After a brief time in private practice in Washington, D.C., she became a law professor, first at Chicago and later at Harvard. She then became dean of Harvard Law School, and in 2009 was appointed by President Obama as Solicitor General of the United States, the very first female Solicitor General. She was then appointed to the Supreme Court in 2010. She is known for her intellect, for her incisive questioning from the bench, and for her creative and demanding use of hypotheticals in oral argument that always go straight to the heart of the cases before the court. She is both an academic and a practitioner on the highest level, and those two traits have given her a unique perspective on the law that she brings to the bench. In the pre-session we just had with the students over in Tishman, Justice Kagan spoke about her time clerking for Justice Thurgood Marshall. I would encourage everyone, when, like me, you're up at 2 in the morning on a Saturday, Google C-SPAN Thurgood Marshall Elena Kagan, and you will find an amazing discussion hosted by the Supreme Court Historical Society in the court's courtroom. And it's a group of former Thurgood Marshall clerks talking about their time as clerks, Justice Kagan among them. And it is a wonderful, wonderful series of recollections about Justice Marshall and the effect that that clerkship had on an interesting group of clerks who all went on to prominent careers in the law after that. And without any further ado, I would like you all to join me in welcoming Justice Kagan here to NYU.
Thank you, Troy. And if you're really looking for material, I mean, figure out a way, because Professor Murray, the first question she asked me when we went to this overflow room was talk about Thurgood Marshall, and I really appreciated that question. And there should be some way of getting access to that, right? Because it's just like, you don't have to listen then for an hour and a half. You just, it was like about, 5 minutes, 7 minutes, something like that. So thank you for asking me that question. I really appreciate that, the opportunity to tell law students in what is now, I mean, it seems like ancient history to everybody, right? And to tell law students.
To our law students, it's ancient history. To the rest of us, it's very
That's
recent
what I meant.
history,
To everybody like those students who weren't, to tell students what he meant to the development of the law in this country, and for me personally, what an extraordinary experience it was to work for him.
Well, the year that you worked for Justice Marshall, Justice O'Connor was also on the court, and Justice O'Connor, the first woman on the court, famously had an aerobics class that apparently all the female clerks in the building were encouraged to take, but you dissented from the aerobics class. You said you preferred to play basketball upstairs, and you played basketball instead of going to the morning aerobics class, but you injured yourself.
Yes.
And so
Can I tell the story?
Go for it. I'm going to let you cook. You go.
Is there a question after this story?
Sure. We'll get there.
But can I say before that, if there's like one great thing to read about Thurgood Marshall was written by Justice O'Connor, who wrote, after he died, like everybody wrote their 5 or 10 pages about Justice Marshall and his life and what he meant for the law. But Justice O'Connor, I forget what it was called, but it was something about storytelling in the law.
The raconteur.
Yeah,
the gift of a raconteur.
And this person who could, and most people cannot do this, let's be frank, but could sit in a conference of the United States Supreme Court and tell a story that kind of made the law real for people in a way that it hadn't been, and that might affect their thinking of what had seemed an abstract legal question. And she was like it's a marvelous piece about him, and it kind of gets to the core of him, and also teaches you a little bit about the way law works. Yeah, so she was, I clerked in 1987, so she had been on the court, I don't know, about 5 years, and she did have this famous aerobics class. She invited, she was the only woman on the court, obviously, and there weren't many female clerks on the court either. I mean, there were, I think, of about 4 times 9, 36. Of those 36, only 8 of us were women, which is very different from the way the court is now. And they weren't very evenly spaced either. Like Justice O'Connor had 2, and Justice Marshall had 2, and Justice Blackmun had 2. And then everybody else, you either had 1, or I think there were 4 chambers that were all men. And would be very unusual today. So it really has changed. We basically have parity among our clerks today, but not then. And Justice O'Connor had this exercise class. It was kind of 1980s style aerobics, you know? It was like those Jane Fonda tapes, exactly. Except they were probably done at a somewhat less energetic, because Justice O'Connor would invite lots of her friends. And although Justice O'Connor then was younger than I am now by a fair bit, they all seemed very old to us. And she did tell all the women clerks, these 8 of us, like we were invited too. And the degree to which this was an invitation and the degree to which it was a command depended on whether you were clerking for Justice O'Connor. Okay. So if you were one of Justice O'Connor's clerks, it was a command. And I said Justice O'Connor had 2 clerks. One of them was an amazing athlete, all right? If I say like amazing, she was a long-distance swimmer, and I'm not making this up, she swam the English Channel the year before she clerked on the court, all right? And before she would get to work every day, she was in the swim club in Washington, D.C. with a lot of, and before she would get to work every day, she would swim a few miles, you know? I don't know exactly how much, but a lot. And then she would have to go participate in this like aerobics class, which seemed a little bit ridiculous at the time. I fancied myself like, I'm really not a great athlete, but I've sort of fancied myself like I do sports. I don't just do aerobics. And the Supreme Court has a basketball court. And
the highest court in the land.
The highest court in the land. It was then also, we've since improved the shape of the basketball court, but it was then the easiest court in the land to get injured on because the floor was literally concrete. So pretty much everybody got injured.
So you all didn't care about tort reform either. Okay.
There was a moment the Chief Justice knew about this because the Chief Justice used to pick clerks who, among other things...
Tennis players.
Yeah. They had to be tennis players. And unlike most people who had 4 clerks, he only had 3 clerks so that they could play doubles together. And his clerks, like one of his clerks got injured and then another of his clerks got injured and he said, forget it, you can't play basketball anymore because I'm losing my tennis game, you know? But not deterred, because there you are, you're in your late 20s and you think you're invincible. Not deterred, I played basketball up on the highest court of the land, and one day I did get injured, and I was walking around on crutches for about 3 weeks or so. One day I was walking down the hall, and Justice O'Connor was walking the other way, and like most of the justices would have just passed me by, you know? But Justice O'Connor did not. Justice O'Connor stopped and said, what happened? And I said, I injured my leg playing basketball. And she looked at me very sadly, sort of shook her head, said, it wouldn't have happened if you had come to exercise class.
She was waiting all year for that. She really was. So, a follow-up question. You mentioned parity among the clerks. There's almost parity among the justices.
Yeah.
So 4 of the 9 are now women, and obviously very different from when Justice O'Connor served on the court, or even when Justice O'Connor and Justice Ginsburg served on the court. But is parity just merely symbolic at a moment where it feels like we're really regressing on women's rights, even as there's actual parity at the court?
Yeah, well, I've always thought that the reason to want representation and to want parity has very little to do with actual outcomes. I mean, it turns out women think a wide variety of things.
Weird.
What?
Very weird. Women have different opinions about things.
There you are.
Yes.
So you can find women who represent
Yeah.
all kinds of different views. And so the fact that there are women on the court, I think, except on, like, I can kind of, if you want, I'll talk about one case where I think it might have made a difference. But, for the most part, I don't think
Yeah.
it makes a difference as to outcomes. I think what it makes a difference for, and I think that this matters, sometimes I think even before, now we are now 4. For a while we were 3, and that was like, I was the junior justice for 7 years. I was down on one end of the court, for the bench for 7 years, and for the same 7, or in her case 8 years, Justice Sotomayor was on the other end of the bench, and Justice Ginsburg was in the middle. And I used to think, like, boy, you're having women's voices coming from all different directions, from the sides and from the middle. And I used to look out in the courtroom, and there are a lot of school groups that come to the court and think, what a great message this sends to all those girls and also all those boys about women's participation in our society. And now we're 4, and it's even more the case. And we're not shrinking violence,
I've noticed.
If you put the 4 of us together and then compared it to the 5 men, I am sure beyond any doubt that we speak more words, more minutes, whatever, than the 5. So when you're in the courtroom, it feels like there's, that is, I mean, it's not entirely a woman's court, but as I said, I don't think it's a matter of outcomes for the most part. I think it's a matter of, like, what messages you're sending to society about the role of women in this society and about how they can participate at the highest levels in courts of law and in other forums as well.
So can I ask a little bit more about just sort of the administration of the court right now? There was some discussion just this morning about the court's caseload. And so I think in this term that's about to start, October term 2024.
What happened this morning?
Well,
Did I miss something?
I don't think you did. Like, you probably already knew about it. The rest of us just heard. The caseload is rather low for the court. And there are lots of reasons why that might be. There are currently about 60 cases docketed, and it could be the case that they're saving room for perhaps election-related disputes that are likely to arise as the year goes on. But when you clerked on the court, you mentioned that you probably heard about 140 cases a year versus 60.
So whenever my clerks, of course, complain about their workload,
I walked to school in the snow.
20 miles barefoot.
Yeah.
And we did 140 cases.
But that's a huge drop-off from 140 to 60. So what explains the diminution? And you're certainly working as hard. I mean, you've said that. Like, you don't feel like the pace has slackened in any way. So what accounts for the low number, but the maintenance of the sense of burden, I guess, on each individual's chambers?
Yeah, so most of the drop-off happened before I became a justice. So this is now my 15th year on the court, so it happened before then. And I think that there are, went from 140 to 100, like almost overnight. It kind of like took a deep dive, and nobody can quite figure out why. Everybody has their theories. The Chief Justice's favorite theory has something to do with the rise of legal research tools and the fact that courts can figure out what other courts are doing more easily, and that means that we get fewer circuit splits, and part of our business is, of course, resolving circuit splits. So that's his idea. Somebody else has said, and I think that there's a lot to this, that the huge drop actually occurred when Justice White left the court, and the theory is that Justice White would vote for cert for anything. And it meant that there was not, you didn't have to really get 4 votes, you just had to get 3 votes. And so when he left and he was, I'm going to say replaced by, I forget, Justice Ginsburg?
I thought it was, yeah, okay. Was it Ginsburg? Yeah, Powell was O'Connor, yeah. Okay. Ginsburg?
Justice.
It doesn't matter.
I give up.
Okay, it doesn't matter.
That had something to do with it. I don't know. Some people say that the scope of the court's docket has to do with what legislation is passed, because if, like, Congress is very active, it can very much increase the number of cases, the number of disputes. I'm not sure that empirically holds. But I will tell you what's happened since I've become a justice. So then it was still low. Like, when I remember my confirmation hearings, I was asked about this by senators, like, why is your docket so low? Because it was about 80,
Yeah.
and now it's gone down to about 60. And what's happened, I think, since in those 15 years, I don't actually know why it's continued to drop. I don't think it's what you said, that we're holding space. I think we know that
Yeah.
the state of our docket is low. So I don't think it's that. I will say the reason why I think, to me, it seems like there's been we're still working really hard is because of the rise of something else, which I don't think is connected to it.
Okay.
Or if it is connected, like, I haven't figured that out. But in the last 15 years, I would say that what's happened to our work is that we spend a ton more time doing emergency petitions.
So this is the shadow / emergency
The
docket.
so-called shadow docket,
Yeah,
right?
okay.
Which, you can argue about whether it's shadow or not, or whether it's just like a different docket.
Yeah.
And this is the set of cases which people bring to us saying, you have to solve this right away, even though it hasn't gone through the regular lower court process. And you have to, like, either give an injunction or stay in injunction and do something very quickly while other courts are operating. And that, 15 years ago, we just didn't do that. And so why are we doing that now? I mean, I spent, like, this summer, we've had an enormous number of these, some of which we've resolved already, some of which are still pending, but they were all over the place. So it used to be that our summers were kind of off. That's not true anymore because of these. So why have they happened? I think it mostly happened, it started to happen during the Trump administration. And the reason, I think here's the story, is that the Trump administration would issue a policy, and people would immediately go to court to contest that policy, and they would go to a fairly sympathetic court. So during the Trump years, they would go basically to the Northern District of California. And courts started giving injunctions, and those injunctions usually swept far beyond the parties or the district. There were nationwide injunctions started up. It weren't an entirely new thing, but they started being used more and more. And then so that they would say the Trump administration cannot implement this policy anywhere until we say it can. And until we say it can, I mean, that could have lasted for years, right? And so, I think that this is perfectly understandable. I mean, the folks in the Trump Solicitor General's office said, well, what does that mean? I mean, the president put into effect a policy, and now it's been enjoined. And if we wait until the Northern District of California does its business and the Ninth Circuit does its business, and if we have to wait, the administration is going to be over by the time the Supreme Court is able to rule on it. And so they started, and it was pretty new to this Solicitor General's office, but very understandable. They started bringing these applications, and I think the court was, sympathetic to a fair number of them, and so it approved those applications for a fair number. It basically, it took off an injunction that a district court had put into effect. And that encouraged everybody to start bringing these. And of course, it's totally symmetric, right? The exact same thing is happening in the Biden administration, right? Where the Biden administration puts out a policy and everybody runs to Texas to challenge the policy. And Texas actually has an even more, a way in which you can really pinpoint the judge you want to get, and the judge puts into place an injunction, and then it just stops the policy. And then you're having to think, if you go through the normal process, now it has to go through the Fifth Circuit, and by the time it gets to the Supreme Court, the administration will be over. So this is a very difficult problem, and it's a symmetric problem. It doesn't really matter who's president and who's not president. But the fact that the court started saying, oh, this just can't be the case, started both the government and non-governmental parties started coming to the court in ever increasing numbers saying essentially, we want one of those too. And it's a very hard problem because, there are times when I've approved relief like that, and there are times where I think, it ought to be approved in the kinds of cases where you just think, how can it be that things are stuck in their tracks because of one district court, and it's going to be 3 years until the Supreme Court gets to it. On the other hand, I don't think we do our best work in this way. We are usually operating on the basis of briefing that's much more limited than the briefing that we ordinarily get. We're operating without lower court opinions or with only the sketchiest lower court opinions. And lower court opinions actually help us do our business. Lower court judges are really steeped in the record of a case. They create the record at the district court. They've thought a lot about it. It's just helpful to have other views when you're staring at a case. So I think we do not do in our best work when we decide cases in this way. I think because of that, we've started in the last year or two saying, well, okay, we won't do it just on the papers. Instead, we'll grant argument. And often that means that we'll grant cert before judgment and put it on the argument calendar so that we get argument in a case, so it allows us a little bit better to understand the thing before we decide it. And I think that that's been a good development. Like, it's better than not having argument in a case like this. But even that, sometimes it doesn't really address the real problem, which is that the case kind of isn't fully suited for it's not ready for our resolution. And so I think we have to do this, grant these emergency petitions with real restraint, understanding that it's not where we do our best law, and that often what we're looking at is not the way the case is going to appear if it were allowed to follow the normal course. And the arguments that we're being presented with are not the best arguments that we would hear if the case followed its normal course. But on the other hand, realize that sometimes, for the reasons that I started with, you just can't leave something in place of great importance for 3 years because they happened to find a district court, whether it's in Texas or California, and then it's just going to be 3 years before the Supreme Court has something to say about it. So it's a tough problem.
Well, and you've actually been very critical in writing of the shadow docket. After SB 8, you wrote, I think, a quite strong dissent about the use of the shadow docket, raising the transparency concerns, the concerns about allowing issues to percolate at lower courts. And some of this came out, again, too, in a decision that was on the merits docket. So this is Moyle versus United States. See, that's the court not wanting you to say anything about this. Moyle versus United States, which was the Idaho case regarding EMTALA, the Emergency Medical Treatment and Labor Act. The court ultimately determined that that case was not ready for review and that cert, in fact, had been improvidently granted. And you wrote a concurrence there. Can you say a little bit about your concurrence and why you felt it was important to concur in that judgment? Because you've often been critical of the multitude of separate opinions, including concurrences at the court.
Right. I would say I don't really view this as like a concurrence in the sense that I've been critical of it, because EMTALA, this was the case, came out of Idaho. It was, Idaho had put into effect a law that basically would only allow abortions if the mother's life was in danger, and did not have a health exception. So that if there was danger to reproductive organs or kidney function, but there wasn't a death danger, you couldn't have an abortion. And there was a challenge to that, and it came to us on this emergency docket because the Idaho District Court had put an injunction on the law, and we were asked to remove that injunction so that the Idaho law could go into effect. And when it came to us, they just said, remove that injunction right now. And this is an example of what I was talking about, that there is an increasing tendency on the court to say, like, we should at least, like, do this in a way that allows us to get
Right.
argument on
To migrate
something.
it to the merits
To
docket, so
migrate
yeah.
it to the
Okay.
merits docket in some way so that we can get better briefings, so that we can get better argument. And so that's what happened. We did cert before judgment, which meant that, you know, we just had the district court's
Right.
preliminary injunction order and didn't have anything else. And eventually we did dismiss it as improvidently granted, is what we called it, which is basically the court's admission that we should never have taken the case at all. And there were three opinions. There were two opinions that were in support of that judgment, and there was one dissent. The reason I say it's not really a concurrence is because the two opinions in support of the judgment was one line. It said, we dismiss this case as improvidently granted. That's your per curiam opinion. And then we couldn't come up with a rationale that 5 people agreed on for why that was true. So 3 people said, essentially we said, look, this was improvidently granted. We should never have taken this case. And we gave our reasons for why we should never have taken this case. And then 3 people, and this was Justice Barrett wrote for these 3, and it also included Justice Kavanaugh and the Chief Justice, basically said, this is not the case we thought it was. And I totally take them at their word for that they thought it was a different case presenting different kinds of issues, that by the time the case got to us, a lot of the arguments had changed. The state was saying things that it hadn't said in the first instance. And, you know, although I thought, like, this was a mistake from the get-go, they thought, like, well, we don't, you know, we just thought it was one kind of thing, and it turned into another kind of thing. And it's a good reminder of some of the things that can go wrong if you do this kind of decision-making too often, because you're just being presented with these cases in such a preliminary way. And without without an expansive sense of what the case is really about and whether, you know, you will have anything useful to say about it at this point. I mean, it reminds me a little bit, just to take the discussion off of the emergency docket and just to sort of talk about how we grant cert in cases. You know, lots of times when we grant cert in cases, we go around the room and we discuss whether a case is appropriate for cert, and somebody will say, like, this is just a crazy judgment. You know, but we'll often, as we discuss these cases, we'll often make preliminary merits arguments about, like, well, how could this be right? This must be wrong. And sometimes that's true. Sometimes it's not. And sometimes the very people who say, well, this must be wrong, because they look at it in a particular, you know, with just on the cert papers, and then when it's actually argued and it's actually briefed in the way people brief merits cases, and we get amicus briefs, and we have more time to think about it, you know, then it turns out that, well, the merits were not so easy as we thought it was, and the very same case that somebody says, well, it must be wrong, is sometimes affirmed, or vice versa. So this is why I think we do need to be restrained about this emergency docket, but at the same time, I think there are definitely places where, you know, there are definitely times where I voted for emergency relief, and where I will in the future, where, you know, where you just can't leave something that's so wrong, involving so much harm, in place for so long until the court can finally get to it. And it's a little bit of a judgment call. It's not something where there are going to be, you know, very clear rules about when you do it and when you don't do it. But so I guess this is, my view is, like, be restrained, don't do it too often, but, you know, occasionally you are going to have to.
Can I talk about something else that you've been very outspoken of? You've talked a lot about why the shadow docket use should be more restrained. You've also been very forthcoming in recent years about the need for ethics reform at the High Court. And indeed, you mentioned at the Ninth Circuit Judicial Conference a few months ago in Sacramento that it really can't be left to you and your colleagues to police each other, that it really needs to go to some outside body. And you suggested that maybe the Chief Justice ought to appoint a panel of lower court judges, trusted lower court judges who might weigh in on these ethics challenges when they presented themselves. And Kelly Shackelford, who is with the First Liberty Institute, which is an advocacy organization that frequently presents cases before the Supreme Court, really took issue with your proposal and you being very outspoken on this. And he mentioned that you were, quote, somewhat treasonous for advocating for ethics reform. I'm not going to say anything more about whether or not you were a traitor for raising this, but I would like to know why it was so important to you, given your position, to speak out on this issue, because you could have stayed silent and you could have just let this work itself out, but you spoke out and you've been very upfront about the need for the court to do this kind of work.
Well, let me say what I said and also a little bit about what I didn't say.
Perfect.
Okay. This was at the Ninth Circuit Conference, and I was asked a question about our new ethics code.
Right.
Because in a prior event, every July I go to the Ninth Circuit, I participate in their conference, and they basically ask me about the state of the law as they see it. And the year before, I had been asked, like, why don't you guys have an ethics code? And I said, you know, that's an interesting thing, and I basically hinted a little bit that we might have one soon.
And you did, and we did. November, we got.
And we did. And so when I went back this July, they said, well, how about that ethics code? And, you know, some people are critical of it. What do you think? And so I talked about that. And so I'll first tell you just like what I said. And I said, I think it's a good ethics code. I mean, it's been criticized a little bit because like the code itself, like what is written down there, I think is good. It's been criticized some because we did depart in some ways from the ethics rules and the ethics principles that apply to other kinds of judges, and we did do that, and we explained, we in each case identified what those changes were, and we tried to explain why we were departing from the rules that other judges used. And I thought it was thoughtful, and I thought it was, you know, when we departed, we had an explanation, and a good explanation for why, you know, the Supreme Court is in some respects different from other courts. So the first thing I did was sort of defend the ethics code we had, but then I said the criticism that I've seen that I think is more legitimate is that we didn't do something in addition to issuing an ethics code, which is we didn't come up with some kind of enforcement scheme. And I said what I think is true is that, you know, most rules have enforcement schemes attached to them, and they have enforcement schemes so you can make sure that people are complying with the rules and so that the public has confidence that people are complying with the rules. And I said we didn't have that. And then I suggested that that could be put into place by the court. And particularly, I suggested a scheme that would involve the Chief Justice basically appointing a committee of respected judges, be they retired, be they, you know, just very experienced, respected judges on the bench, who would be assigned the task of dealing with complaints about our behavior. And I do want to make clear, because there have been other proposals, and some in the wake of what I said, after what I said, that I was not speaking about what Congress could and couldn't do. And the reason I want to make that clear is because, you know, if Congress ever were to act in this vein, I'm sure that there would be legal questions raised about what Congress can do in terms of imposing requirements on the court. And I don't want to say anything about that because, you know, one day, who knows, I might have to decide a case involving that. So I was just talking about what we could do. And I thought, you know, I said I have a lot of faith in the Chief Justice's. Chief Justice forms committees to do all kinds of things, and I think that he does an extremely good job of that and had a lot of faith in our ability to do that. I thought it would be a pretty good thing. Now, since then, I guess I've heard two kinds of criticisms of that, and they really come from two different directions. So one criticism I've heard is, no, this would just gin up or increase the number of baseless charges, of meritless charges against judges. And look, if that were to happen, that would be a bad thing. I'm not sure why it would happen. I mean, there's like lots of ability now to make unfounded charges about what justices do and don't do, so I don't really see how it would increase that. I mean, sort of to the contrary, right? It gives you a mechanism where people can say that's a meritless charge, that's even a frivolous charge, which there are. And, it would have judges be able to sort the wheat from the chaff and to say, like, forget about that, like, stop talking about that, that's ridiculous. So I guess I'm a little, that criticism a little bit confuses me. The other criticism is from the other side, and it says that's not nearly enough. Yeah. Because how can you expect a bunch of lower court judges who, if they're not retired, their rulings are coming up to the court, how can you expect them to be a sort of serious enforcement mechanism? And I guess I get that, that idea. I just think judges are not, they're not so afraid of us, I think that that's in the picking, basically, and I think that there are plenty of judges around this country who could do a task like that in a very fair-minded and serious way. So I guess, it seems like a good idea to me. It seems like a good idea in terms of ensuring that we comply with our own code of conduct going forward in the future. It seems like a good idea in terms of ensuring that people have confidence that we're doing exactly that. So it seems like a salutary thing for the court. And, as to this somewhat treasonous charge, sort of like somewhat pregnant or something, But okay, I don't know. I think I just sort of said what I said. I just answered that. And I don't want to dignify it any further.
Let's speak about collegiality on that note. Lots of stories have been written about your former colleagues, Justices Scalia and Ginsburg, and their very warm friendship and their collective love of opera. And we've seen in recent months, Justices Barrett and Sotomayor go out on a girls' trip, explaining that, although there are differences on the court, they are still very good friends. So, I mean, you all are at great pains to reassure the public that despite the fact of a 6-3 conservative supermajority and the differences that might present, you all are still working together. You are friendly. It is a friendly work environment. It's a pleasant work environment. Does that matter to us if the outcomes are so ideologically riven?
Yeah. Well, I think it matters if it's, I think it matters as a means to an end, right? Mm-hmm. I mean, for sure it's like a good thing for us that when we like each other, it's nicer than when people don't like each other, right?
I work on a faculty. So
exactly.
Yeah.
Exactly. I used to too.
I've heard.
Like for the people up there, it's like a good thing if you like your colleagues. And I suppose that means like if it's if you hate your colleagues, then you're in a bad mood, and then who knows?
I feel like I have to say I love my colleagues because my boss is right here in the front row. Okay.
But here's what I think it is. Like I basically, if that's all it does, then I honestly think people shouldn't care. People shouldn't care that Justice Scalia and Justice Ginsburg went to the opera together. They shouldn't care. Like, I've taken up golf recently, and so I spent a lot of time talking with the Chief Justice.
My husband over here just looked really interested and perked up. He is an avid golfer, and like, if you want to go golfing, that's your man right there.
Okay, all right.
Okay.
So I talked to some of my colleagues about golf a lot. But why should you care about that?
Who are the golfers?
Justice Kavanaugh is a good golfer, and the Chief Justice is a good golfer.
Scotch
And the Chief
golfer?
Justice's wife is very
Really?
into golf too. So we talk about golf a lot. Why should you care that we talk about golf a lot? The reason for you to care, I think the only reason for you to care, honestly, but if it leads to something else, then it's a good thing to care about. If it leads to better decision making, if it leads to people who can more see each other as human beings, if it leads to people who are more able to have really good conversations with each other, and that means not just about golf, but about law, and that somehow the conversations that you're having about opera are extending to the conversations that you're having about the court's business, then it's a fantastic thing. But the proof is in the pudding as to that, right? Like if you think kind of it just is about opera, then it seems to me not sufficient. It's meaningful and it's sufficient when these relationships that might be founded in, like people talk about, we have lunch together a set number of times, and we learn a lot about each other's families, we learn about what people are reading, and this is all good if it means, and hopefully it does mean, but it's not guaranteed that it will mean, but if it means that we take that, like I know that all these people are good human beings and I can have conversations with them about many things, and then we take that and we apply it in our conference to our conversations about law, and we can see things from another perspective, and we can figure if Justice XYZ says this, even if I don't immediately understand why, I'm going to make a greater effort, and I'm going to see if we can establish some kind of communication with each other, then it's a good thing. And then it's important.
Does
But
it happen
then-
like that now, given the
I think
ideological
I
split?
think it can, but I think it does. It doesn't have to, and that's what you should be looking to, right? It should not be sufficient for us to get up and say we go to the opera together. What you should be looking to is, do these people look as though they can communicate about law together? Even if they don't agree all the time, we are not going to agree all the time, But are these people looking as though they're trying to reach consensus? They're trying to, they're trying to figure out what each other's thinks and understand what each other's thinks, and trying to find places of agreement where they can. That's, I think, what you should be judging us on.
So we have time for one question. We're going to have a little game before we close out for lunch, but we have one last question.
Sounds scary.
Don't be scared. It's going to be great. But I actually had to cancel my family law class, and my students are in the other room listening to this. And so in order to satisfy the New York State bar examiners, I have to ask you a family law question, so this counts as class time.
Are the New York State bar examiners really looking to that?
I try to keep my side of the street clean, and that's what I'm doing here. So in 2022, when the court decided Dobbs versus Jackson Women's Health Organization overruling Planned Parenthood versus Casey and Roe versus Wade, there were real questions that you and your colleagues raised in your joint dissent about other rights of intimate life, like, for example, the right to contraception protected in Griswold versus Connecticut, the right to same-sex marriage protected in Obergefell versus Hodges, all of which are rooted in the same substantive due process and privacy logic as Roe. The majority disclaimed that those rights were at issue, although your other colleague, Justice Thomas, wrote a separate concurrence in which she said, nope, they are definitely in play here. And in fact, I invite litigants to bring cases challenging these landmark precedents. Last term, in October term 2023, the court decided a case called State versus Munoz, which was an immigration case, but the court ultimately held that a citizen spouse has no fundamental liberty interest in her non-citizen spouse living and residing in the United States. And some of us, myself included, others like Dahlia Lithwick at Slate, saw this as a straight line running between Justice Thomas's concurrence and Dobbs and these rights of intimate life that apparently are, or maybe are not, imperiled. Are we overthinking this, or are these rights actually in danger?
Well, if they are in danger, I'm not sure it's because of Munoz.
Okay.
So I guess I'll push back just a little bit
Okay.
on Munoz, but then go back to the first part of your question where you really talked about Dobbs and what the
Right.
dissent said there. I mean, on Munoz, I think what you said, there's a version of what you said that's in the dissent in
Yeah.
that case, and I joined the dissent, so I completely understand what your argument is, and I joined a dissent that, I agreed with. But I guess I'm hopeful that Munoz will turn out to be not such a big deal as maybe in the moment the dissent suggested that it was. And the reason why is because, as the majority pointed out, that, there is this very long-standing history where the U.S. government just gets to make choices about who can enter the country, and that the fact that somebody is a spouse of a person can be ignored entirely by the government, or, in great measure could be. And even the dissent only suggested not that the U.S. resident had any right to have the spouse live there,
Right.
but just that the U.S. resident had the right to have a quite minimalist explanation about why the spouse was excluded. And I think what the majority's point was was just given that history, it's hard to see how you find that right of information, and we're not exactly sure what that right is. Now, as I said, I think that the majority is wrong for a number of reasons. I think in the end, what the majority and the dissent were fighting about was how to read another dissent of the court called Mendel.
Yeah.
And that was a case where there was some explanation requirement. And in my view, the court had recognized an explanation requirement for people on this country as to why certain people were excluded from this country. But that's a kind of localized dispute, and I guess the main point of what I want to say is just you could kind of understand why the majority said, look, we've never recognized, even among married people, the right of a U.S. citizen to have a spouse enter the country, and this just follows from that.
Okay.
So maybe you're overdoing it. But
Okay.
I don't think
I've been told I can do that.
But I don't think you're overreading the bigger question. I mean, I think what the dissent in Dobbs said was take this analysis that you've just applied to abortion, and it applies to a lot of other things.
Yeah.
Because the analysis that the Dobbs majority used was, and this is the entirety of the analysis, was to find a right here, we have to find a liberty interest, and we can't find a liberty interest at the relevant time, which was 1868, when the 14th Amendment was ratified, that had anything to do with women being free to get abortions. And because that didn't exist in 1868, there wasn't that history, there wasn't that tradition, then there can't be a right now. And that's the entirety of the majority's reasoning. And if that's the majority of the majority's reasoning, then you could say the same thing for contraception. Then you can say the same thing for interracial marriage. Then you can say the same thing for gay marriage. You can say the same thing for a lot of things. And Justice Thomas, I mean, there's nobody who can say that Justice Thomas doesn't have the courage of his convictions. And Justice Thomas basically said that in his concurrence. It's like, well, you probably, I don't want to paraphrase his dissent. I don't exactly remember the words that he used, but he did sort of say, yeah, that would be a question at the very least. Because the majority makes very clear, that its decision is not based on a particular view of the status of a fetus. Right? I mean, it emphasizes that because it says we're being neutral as to that. We're not getting involved in these deep moral, philosophical, theological issues. Well, if you're being neutral as to that, then the only thing that you're basing your decision on is how you go about determining what a liberty interest is, and they say the only way to determine what liberty the Constitution protects is to look at what liberty it protected in the late 1860s. And it didn't protect the right to contraception in the late 1860s, and it didn't protect the right to marriage among people of different races in the late 1860s, and the same for gay marriage. So I think, that's something, I mean, we made a big point of that in the dissent, and however many years later, I think that just as a matter of logic, that point is true.
All right, so that is a very sobering thought. Maybe we can chase it with a little fun. So we're going to play a game that I have played with Justice Sotomayor when we have done these kinds of conversations. I know there's a bag. You're looking very nervous.
Props.
The game is called This or That. So I'm going to present you with two options, and you tell me which you prefer. It's very easy.
Okay.
Okay. So first, New
I
York.
have to pick one.
You have to pick one. We can warm up.
Okay.
Okay. Washington, D.C. or New York City?
As a what?
As a place that you want to be. A place you'd like to be right now.
Right now, I want to be here.
Perfect, New York. See, you're great at this. You are great
you
at
gave
this
me
game.
help.
You were great at this
You gave me a way
game.
out of my dilemma.
Here's another one: H&H Bagels or Nathan's Hot Dogs.
H&H Bagels.
Okay. See, you're so good at this.
I grew up 6 blocks away from H&H Bagels, but I don't think it still exists anymore, does it?
No.
81st and Broadway, is it still there? It's not there. It's on the east side. It used to be, I lived on 75th and West End, was not, that's where I grew up.
A lot of people eating carbohydrates.
And on your way to Zabar's, you would stop at H&H Bagels. Yeah.
All right, so Broadway or the Kennedy Center for the Performing Arts?
You see, the Kennedy Center has other things besides shows,
Okay.
right? So like the Kennedy Center has symphony and opera and stuff. It's like a apples and oranges kind
Lincoln
of thing.
Center versus the Kennedy Center.
Lincoln Center.
Oh, okay, good, okay. This is good. All right, now it's time for the props, okay. I know you're an avid reader. You made some recommendations at the Ninth Circuit that were absolutely first rate. I started reading Tom Lake on your recommendation. It was great, by Ann Patchett.
But listening to it, did you get that part of my recommendation?
So I don't love books on tape.
Well, neither do I, but I specifically said, I specifically said, like, I don't like fiction on tape. I only listen to nonfiction.
But Meryl Streep read
But
this one.
Meryl Streep,
But I like podcasts, like you might have heard.
yeah.
Yeah. So I listen to podcasts, but
All right,
not.
for everybody else other than Melissa, if you read Tom Lake, don't read Tom Lake. Listen to Tom Lake, all right?
All right, I'll come back to that. Okay, so I have some books. I'm going to ask you which of these books, and this is going to be 3, so you have a
Have I read them?
I don't know. We'll find out. Lovely One by Ketanji Brown Jackson. I assigned these for class once. My Grandfather's Son by Clarence Thomas.
You are not going to get me to do this.
My Beloved World by Sonia Sotomayor.
I'm taking the 5th.
I actually think they're all quite good. I assign chapters from both of these in my class when we talk about affirmative action, and I think I may assign a chapter of this when we do it as well.
So I have to say I haven't read Lovely One yet, and message to my colleague, I haven't gotten my copy of Lovely One yet. So,
I think you have to have a podcast to get it.
but I agree with you about those other 2 books.
They're both very good.
They're
highly-
excellent.
So here's another one.
Not a prayer. Harvard.
We don't know that one. We don't know that one here. You can.
I'm at NYU, so right now I would love to be at NYU.
Okay, I'll put this one down. You've been such a gracious guest. We're so delighted to have you here. Thank you so much for helping us to inaugurate this lecture series. What a fantastic opportunity for our students and for our community. Thank you for being here. I'm going to let you have the final word, and you can dissent if you would like, but I hope this will be a concurrence.
It was a pleasure, Melissa. And it's partly a pleasure because you're a fantastic interviewer.
Thank you. You are always welcome on the Strict Scrutiny podcast.
Oh, okay.
I think I already know your answer.
That'll be the first thing on my list.
Whenever. You take your time. But please join me in thanking Justice Kagan for these warm.
Thank you, everybody.
You were terrific. Thank you so much.
Thank you. Very kind. Okay.
All right. March. Yes.
Thank you very much.
Thank you so much. That was just enlightening and entertaining, and I loved all that New York representation, especially the H&H. Glad to hear it. But anyway, thank you both so much. Thank you. I want to extend truly our deepest thanks to Sybil Shainwald and her family. Thank you so much for trusting us and trusting the Birnbaum Women's Leadership Center with this lecture. We are so grateful. We cannot wait to do this again with you. Thank you so much. I also want to thank, there are so many BWLC members here in the audience today. So for folks who are not part of our center, know that there are law students to speak to, there are alumni to speak to, there's an advisory board to speak to, there are founders to speak to. It's a really amazing entity, and I really look forward to you all getting to know us as well. And I couldn't end this day without giving very special thanks to the members of our small but mighty team who made this possible, especially Shirley Dang and Sherry Arnold, who have been working nonstop with your amazing staff. Justice Kagan, they've been a pleasure to work with. We were thrilled to pull this off together. And with that, I welcome you to all. Enjoy your lunch, break bread together, make community together. Thank you so much for being here.